get things started. Here's the disclaimer, which I suspect we'll hear again. We're not here to give you legal advice. Okay? We're here to give you legal background information. Okay? Everybody's property is different. Everybody's interests are different. So keep that in mind. When I first got started with this pipeline business was in January. I think it was in mid-December that the Daily Item had their first article about UGI applying for starting the process with FERC. And at the January chapter meeting of the Sierra Club, I spoke with a fellow who's involved with the Lehigh Valley Group, who is an attorney, and he specializes in zoning. And he told me two things that day. Number one, you can negotiate anything. And number two, get a lawyer who's familiar with this field. Okay? Because he specializes in zoning, and I don't know if any of you are familiar with the Jessup power plant dispute. He's acting pro bono as the attorney for the local group in that area. Again, that's a zoning issue. If you're familiar with that power plant at all, it's a zoning issue that's involved there. We're very lucky to have Michael Faherty. Am I saying that correctly?
Yes. Faherty. Faherty.
Faherty. I want to keep trying to stick an R in there to begin with.
Or an L.
Faherty. If you're writing things down. We were searching for a speaker, and I contacted Tom Howe, who's an attorney, a retired attorney who works for the chapter, and he suggested I get in contact with a group in the Cumberland and Perry County area, and they recommended Mr. Faherty to me. I'll read through his biography here. I was going to try to write something out, but it's easier just to copy from the website. Mr. Faherty leads the Faherty Law Firm in the advocacy of property rights and providing eminent domain law services to Pennsylvania property owners. He provides legal representation to property owners. He provides legal representation to property owners in conjunction with his services as the only Pennsylvania representative to the Owners Council of America. The Owners Council is the National Association of leading eminent domain attorneys and property right advocates. Mike's practice location is in Hershey, Pennsylvania. It facilitates statewide practice of eminent domain law. He began practice of eminent domain law in 1989 as a condemnation lawyer for the Pennsylvania Department of Transportation. He quickly obtained decisive jury verdicts and became the lead eminent domain attorney for the Pennsylvania Department of Transportation. He began the private practice of law in 1992 at a large Philadelphia law firm. He later returned to central Pennsylvania, where he progressed to serve as president of the Pennsylvania Defense Institute. He developed a Harrisburg litigation law firm before founding Faherty Law Firm. He is licensed to practice law by the Pennsylvania Bar Association and each of the 3 federal court districts of Pennsylvania and the United States Court of Appeals, 3rd Circuit. Like regular lectures on eminent domain law, his eminent domain property rights practice has recently focused on the rights of property owners threatened by pipelines. He is a contributing author to the Pipeline Safety Trust publication, Property or Landowner's Guide. Whoops, that's the second page. Pipeline Safety Trust, if you're looking for information, I'll give you two places to go. The Pipeline Safety Trust and the Pipeline Safety Coalition. That one is pscoalition.org.
Pipeline Safety Trust is the national organization that provides information to property owners from a property owner's perspective it is the booklet. They produced the first booklet that was found on the corner of the table there. So you have about a 30-page booklet there that I think is the best source of information for property owners.
I took an online course through the Pipeline Safety Coalition, and that book was one of the reading materials that we paid when we went to each section. Again, I told Mr. Faherty when he said he would come up here, he made my day, and I hope he makes your day tonight. Thank you.
Thank you, Jack. I very much appreciate the opportunity to speak to this group and travel through the beautiful Pennsylvania countryside to come up from Harrisburg. I commend your efforts on the Sierra Club in supporting our wonderful environment. I also thank Sunbury Social Club for hosting us this evening. I appreciated the introduction, Jack. I'm here to advise you on your constitutional rights, which are fundamental, and your property rights are fully protected by our United States Constitution and the Constitution of Pennsylvania. Actually, Pennsylvania before the United States Constitution, as it worked out. But you may be aware of the Fifth Amendment to the United States Constitution, that no property shall be taken from you for public purpose without due process and just compensation. Those are the fundamental terms behind this process of eminent domain. And eminent domain can be used smoothly and effectively and properly. Unfortunately, it's often abused, and that's some of what I'll be talking about tonight. I'll take about the next 45 minutes and talk with you about property rights, about easements, about eminent domain, and about the Sunbury pipeline. I'll touch on a variety of aspects of that, reflecting my perspective of being an advocate for property owner rights. Some people can be of other perspectives in the room, and that's fine. I'm not going to give you any disclaimer. I'm going to try to give you some good legal advice and tell you to protect your property rights and protect yourselves against a company that's trying to take property from you and not pay you what is protected by the constitutions. I came into this area of law when I started practice law in 1989, working for PennDOT in eminent domain. And there I saw some ugly things, and that's what leads me to be on this side of the fence representing the property owners. I worked down in Harrisburg, and we had a fellow in District 8 of PennDOT in Harrisburg by the name of Whitey. Whitey Brownwell was, your grandfather and Santa Claus rolled into one. He was about 6'2" with a big belly and a white beard, great smile, a jokester, warm as can be, and he'd rob you blind. And that was some of the abuse that I saw and lived with. So within a couple of years, I left that side of the fence, and now I'm happy to be an advocate in Pennsylvania, and to the extent that I have a role nationwide with the Owners Council, being an advocate for property owner rights. Your property rights, are threatened by the proposed Sunbury pipeline of UGI Corporation, and they could be threatened in a way that is consistent with eminent domain or in an inconsistent way. Before I go further into that, I want to reference my paralegal Sarah, who is sitting over at the side here and had some of the information. Sarah can be available afterwards and might be of some help to you. With Sarah are the documents, some of the documents that are available. This is the Landowner's Guide from the Pipeline Safety Trust. I was very happy to be a contributing author to the publication. I think it's one of the best, or the best, for your education on property owner rights. About a 34-page booklet. My biography is over there. Also some notable cases. A lot of my time in the recent years have been opposing pipeline companies or utilities that are taking property rights. Whereas traditionally, before this Marcellus shale boom, much of the condemnation work in Pennsylvania might have entailed work against PennDOT or the Turnpike or maybe the Sewer Authority, some other public entities. Recently, this tremendous boom of Marcellus shale bringing some good and some bad to many of our communities, has brought this surge of pipelines. On my eminent domain blog, PA, you can see a listing of some of the pipeline projects that are planned. Well, there are currently planned about 1,000 miles of pipeline crisscrossing Pennsylvania. And we here in Sunbury are on the edge of that. And so a lot of the pipeline activity, if not this Sunbury pipeline, another pipeline might be crossing through your backyard in a few years. So happy to provide some education focusing on the Sunbury pipeline, but I want to explain eminent domain in general, and talk about easements, and talk about how the process generally works, and we can talk some specifically about the specific project. One other handout that's over there is a large-scale map that shows the route of the 35 miles of the planned Sunbury pipeline. Some of you also may have received a letter from me just in the last day or two offering my services and showing you a plan or a map of how the pipeline would cross your property. There's a brochure in that also describing some of my services and background. I advocate for property owners is what I do in the realm of eminent domain and property rights. Your property rights, if you own property from whatever source it came into your hands, is a property that's been described in Pennsylvania law as being quaintly stated, and that's in the case law. It says this is quaintly stated, from the center of the earth to the heavens above. So you have property rights that are not only surface rights, but subsurface rights, where the pipeline might be located, not necessarily, but might well be located. And air rights above, surface rights. A property can be mortgaged, you can have a rental of a property. These are sometimes referred to as a bundle of rights, or sticks of a bundle of rights that go with owning property. Well, it's not uncommon to have those property rights restricted or compromised some ways, and the common way is an easement, and that's what we're talking about here, would be a pipeline easement. And an easement is a right of use. It's a property right that runs with the land, or goes with the land through successive owners. And it's a right to use a property for a particular use. As we talk about a pipeline easement, there can be language in the document that conveys that easement or property right that would define what is that right. And it might have a plan attached to it, it might define it as 50 foot wide. There might be also a temporary construction easement, 25 feet wide, next to that. The temporary easement would go away after construction generally, but again, we have to be careful with the terms. The easement is defined by the terms. Often, for a pipeline, you would have the definition of the opportunity to lay, operate, construct, repair, maybe replace. Perhaps there would be easement language of placing additional lines. Whatever in that easement would document would define what those rights are. But generally, it's a right of use, and the underlying property owner can make all sorts of other use of the land that's not inconsistent with the easement. So I have a pipeline on my property. They have a right to use that. They can clear the trees to keep an eye on that and inspect it, possibly from airplanes. They can come onto the land, survey, inspect, etc. But if the easement language is proper, I can use that for all sorts of other purposes, including crossing it, or possibly having a road crossing. Perhaps I could have shrubbery there. Perhaps not trees, but perhaps shrubbery. So I want to emphasize the importance of an easement in the easement terms. Part of the reason why you might consider legal services is to get the easement terms to be favorable to you. These companies left to their druthers, in particular a for-profit company such as UDI, might seek to have terms that are very favorable. For example, allowing multiple pipelines instead of a single pipeline. They might have a need for a single pipeline, and that could be a valid public purpose, but they might try to have easements that call for more than one pipeline, or access from anywhere on your property as opposed to from the pipeline. The terms are something that can be very, very important. I'm working with a number of landowners along the Mariner East pipeline, cutting across Pennsylvania south of here, really coming from Washington, PA, coming over through Cumberland County, the Hershey area, Lancaster, etc. So a little bit further south of here. But I'm working a lot with their proposed easement language these days. And there's about 20 different terms in their approximately 6-page document that are offensive to me as a representative of property owners. Because I'm trying to get rights beyond what they really need. They need the ability to build and operate and safely operate the pipeline. And if somebody acquires those rights, that's fine. Those are rights that run with the land, and we shouldn't interfere with those rights. The company should not be trying to obtain rights beyond what they need. Eminent domain is for a valid public purpose. And here, it seems as if this pipeline probably would meet that standard. We have an application going on by UGI to the regulating federal entity called the Federal Regulatory, FERC, Federal Energy Regulatory Commission in Washington, D.C. That's the administrative agency that's been charged with regulating and monitoring such pipelines. That organization flows from the Natural Gas Act that back from around 1970 provided the approval of natural gas production. Some of us are old enough to remember some energy crises in the past. Well, that was some of the historical context whereby this natural gas was deemed to be so important to our economy and perhaps somewhat to our national security, that this awesome power of eminent domain was granted to natural gas companies. And a company such as UGI can qualify as a natural gas company and apply to the federal government, to FERC, to get approval to build and operate and do a pipeline with the power of eminent domain. By contrast, there are other companies that are regulated by FERC that don't have the power of eminent domain. For the Mariner East 2 pipeline that I mentioned crossing the southern part of the state, FERC regulates Sunoco Pipeline as a common carrier rather than a natural gas company. And so that in that regulation, that company does not have the power of eminent domain. So we get some odd things going on. One of the hopes of some environmental advocates is that, hey, we can get some community groups together, we can oppose this, we can potentially defeat this. And that's possible, but I don't want to give any false hope of that. I've spoken to a variety of other community groups, and I've provided some advice to community groups about opposing it and intervening against it. But to my knowledge, never have those efforts been successful in convincing FERC not to approve a pipeline such as this. So I would think the purpose here, which would bring natural gas from eastern Lyoming County down southwest through this area to Shamokin Dam, a 35-mile pipeline, I expect it will be approved. And when it's approved by FERC, that would be a clear, specific order giving a certificate of public convenience and necessity, authorizing this pipeline and the use of eminent domain. And at that point, they become a condemnor and have the right to take your property from you. The flip side of that, taking the property from you, is just compensation. My usual litigation, and the usual eminent domain litigation, is fighting on the value of property. Unfortunately, condemnors have developed a pattern of very much working to deny the constitutional right of just compensation. Just compensation is a term of art, a specific term, well-defined in the law, that must be provided to the property owners. And that's the obligation of the law, yet these private companies in particular work to avoid doing that. Sometimes public entities too, but I think the private entities are more egregious. And they would often give a lowball figure for the property and try to convince people to sign away their rights, maybe more rights than they should, and accept the very much low figure. Part of why this occurs is that the value of real estate is very subjective. Two different people and two highly qualified appraisers could have very different opinions of value of a property. Well, if you have a pipeline coming through a property, in particular with an explosive substance, that is very harmful and dangerous and creates stigma and destroys value of the property, hurts the potential subdivision, et cetera, et cetera. So one appraiser, qualified real estate appraiser, might say the property is harmed, let's say 50%. Somebody else might say, well, it's just a pipeline, they're probably going to put it underground, There aren't too many explosions, although we know there was one just today or yesterday. But another appraiser might say there's very little damages. So you might have a difference of opinions. Someone might say 5% damage, somebody else might say 50% damage. In the usual eminent domain litigation, we negotiate about that, and often we settle that sort of controversy, perhaps somewhere towards the middle. Here, what's proposed, we need to recognize is a natural gas line, and that's clear, and that's what allows the company to progress, to potentially get the power of eminent domain. But it is a substance that is explosive and dangerous. And in particular, if you have a residential property, if you have people living near it, that property is more harm. I don't mean to particularly scare anybody, but there is the risk of explosion. If there is a leak or explosion, it's not a good thing. I want to read to you some about a leak of a pipeline. Now, this was not natural gas, but we had a leak that I think occurred last night or yesterday. On Tuesday, a 24-inch pipeline ruptured along the Santa Barbara coast in California, spilling an estimated 21,000 gallons of crude oil into the Pacific Ocean. Incidentally, this is the same stretch of coastline which suffered a massive oil spill in 1969, which is credited to the rise of the American environmental movement. The cause of the break of the pipeline is unknown at this time. Owen Bailey, executive director of the Santa Barbara-based Environmental Defense Center, said, "Unfortunately, with accidents and oil development, it is not a question of if, but of when." He might have exaggerated a little bit, but the pipelines do leak, and you can have a natural gas explosion. If the substance leaks from the pipeline, there could be an explosion. If there is an explosion, you have a great deal of danger in a very large damaged area. I have a couple visual aids that you might be curious about here. Starting small to big, I guess, perhaps we'll go. This is an 8-inch pipeline. This is part of the Mariner East 1 pipeline running through the southern tier of the state. 8-inch cast iron, perhaps older than anybody in the room. This was placed in the ground about 80 years ago and taken out last year as part of a replacement or repair of part of that pipeline. So, steel, heavy piece of metal here. The pipelines are welded together. I'm told the welds are often stronger than the pipeline itself. But you can have accidents and problems and leaks. The next size here is the size of this ball. There's a planned pipelines, including this Sunoco 2 pipeline that I mentioned across the southern tier, planned for a 24-inch pipeline. This is a 24-inch ball, so that would be the size of a 24-inch pipeline. You see a dramatic difference between the 8-inch and the 24-inch. My tape measure here is set up for 20 inches, so about that inch, that would be a little bit shorter than the ball here. So about that height or that circumference would be the 20-inch pipeline that's planned for the Sunbury pipeline. It would be planned for an underground pipeline, but we need to be careful with our easement language to make sure it's an underground pipeline. If an entity just acquires rights to lay, operate, etc. a pipeline, they could lay it above ground and potentially have that pipeline exposed to more danger than it would be if it were below ground. So that's an example of some of the terms that Jack mentioned that might be negotiable. I expect that it is going to come through, and I expect that it's going to come through with eminent domain abuse. You might see some very friendly fellows, many of them perhaps with a southern accent, a big smile, that want to have a nice chat with you. Very commonly, these land agents, they'll try to strike up a friendship and find out what you're interested in, what you want to hear, and that's exactly what you're going to hear, whether it's truthful or not. They'll often tell you they can take care of this, they'll do that for you, they'll move up your offer, they'll be back next week. You're special, so they're going to double the offer. Well, let's say you have a farm. Let's say you have 20 acres and you have a house on it. Let's say it's worth $500,000. They might come through, well, there's hardly anything going on here. You're not even going to see this below ground. You don't get a lawyer. It's no damages. Here's $10,000. sign and be happy, and here's the documents and here's the check. Don't sign. Your rights are much more valuable than they would have you believe. Then we come back a little bit later, getting closer to their deadlines. Well, we've moved it up from $10,000 to $16,000. Back a week later, we got you double. We got you up to double or triple. We got you $30,000. Well, the actual harms might be calculated in an entirely different way and be tremendously greater than what they're offering. A $500,000 home that, let's say it's devalued by 25%, you might have $125,000 in damages as opposed to the 20 or 30. Getting some feedback here. Let me know if you're not able to hear me as I talk.
It's not as good.
Okay. Try to eliminate the feedback somehow. So be cautious as a landman come out. They're working to generate profit. They're working to pay as little as possible for your property. They don't want you to be represented. They'll often tell you that they'll put certain things in an easement agreement or a document, but when you get the document, it's nowhere to be found. They might tell you of things that they would help you with afterwards with the property, reseeding or replanting or fencing like that. Well, they're off to Oklahoma by the time that comes around. So what's in writing counts. The easement document is what counts. And what I would generally do for property owners would be review the document, see what interests you have. Different owners have different interests. Somebody might be very interested in making sure those animals are protected in the fencing. Somebody else might want a pipeline moved. Somebody else, the timber is very important. And when I negotiated with Sunoco Pipeline last year, I was able to enter into a number of agreements by which we allocated certain funds to property rights and certain funds of the settlement to settlement of the litigation, and in that way minimize the tax consequences very dramatically. So that's something that we might be able to do also with this company. But you need an advocate. I encourage you to get an advocate, get an experienced domain attorney, me or somebody else, but get somebody. Your rights are valuable. They're much different than being described to you in the public documents and in the landowner phrasing. There are smooth, savvy documents that come out of these companies just with completely false information. For my Mariner East 2 pipeline, they're saying all over these documents they have the power of eminent domain. Well, last year I went to court in York County and obtained a specific ruling in the Loper v. Sunoco matter saying that they do not have eminent domain power. Yeah, they might put information in their brochures and their publicity that's false. So I usually tell property owners, listen to what they first have to say and then use the opposite as your starting point. I'm a little jaded, you might gather. Okay, here's, for this project, what we've described as it's a 20-inch natural gas pipeline. It would be made of steel. And there would be the welds that would go along with it. I would certainly expect it would be underground, if not the whole way. Certainly, generally, it's going to be underground. Pipelines are safer underground, and that's where they should be. This is a $160 million project. It would transport the natural gas from the north, from Franklin Township in eastern Lycoming County, southwest 35 miles to Shamokin Dam, and be serving the plant there for energy purposes. 10% of the pipeline is listed to be located concurrent with existing pipeline. So 10% might be coming through alongside. And when I say alongside, it might be 5 feet away, it might be 40 feet away. But the plan is to have about 10% of it along existing pipeline. So the other 90% would be coming through land that might be not encumbered by any easement. Or you could have some easement. You could maybe have a telephone line crossing, you might have a sewer easement, there might be some other things. But many of the properties would be clean or pristine or unencumbered. So they're properties that might be significantly harmed by the loss of development potential as a pipeline might come through. You would hope a pipeline might come through your boundary along the edge of the property. They like going straight, so We might ask them to move it, but it might well come straight through the middle, or maybe even worse, diagonally through the whole property, running the full length. They don't like to move the property. They don't do sharp angles. They like to come through, and the chips fall where they may. They know that by eminent domain, you have the right of just compensation, but they know also that you would have to take the steps, the affirmative actions on your own to force them to pay just compensation. The Pennsylvania Eminent Domain Code, the concerning law, tells us that in condemnation or eminent domain, that the condemnor must pay estimated just compensation, called EJC in the business. Well, it has to be an estimate. It doesn't need to be a good estimate. It doesn't need to be by an outside company. It just needs to be an estimate. So if they condemn property, before they take possession of it, they would have to pay estimated just compensation. Well, in my scenario from before, they might pay the $10,000, and then it's up to you to file the petition for a board of view to bring them into court and to prove the higher damages. And they know that unless you have an experienced eminent domain attorney, that there's no threat. So they're not inclined to negotiate with you, whether it's for easement terms or for dollars, unless you obtain counsel. And I regret that situation, but that's what the law has allowed to unfold. To get just compensation, I think you need an advocate, an experienced attorney that fights for property owners. What is just compensation is a common question. A term of art in eminent domain law, and it's defined in our Pennsylvania Eminent Domain Code at section 702 as the value of your entire property interest before a condemnation as unaffected thereby. That's your before value. What's it worth before? Minus the after value, which is the value of the property interest remaining and as affected thereby. Before minus after equals your property damages. So that as affected thereby takes into account what the marketplace does. The marketplace looks at the property afterwards as affected thereby. And the effect is not just the strip of land for the pipeline easement that they want to pay for, but the harm to the whole property. Your home, sitting 50 feet away, might still be a nice home in the same physical structure, but it's worth less because you have an explosive substance running through the ground nearby. So that way of calculating the damages by the eminent domain code encompasses the harm to the entire property interest. And generally, the entire property interest would be affected, unless you have a very large property, with some of it being very far from the pipeline. So some of that land, far away from the pipeline, might have minimal impact. Of course, close to the pipeline, you would anticipate the more significant the impact. And that's generally the way the law would look at it. But the law tells us to look at the entire property interest. The law also tells us to look at it from the market perspective. Not what an individual property owner might think it's worth, but what the market would pay, the real estate market. And in particular with the residential property, I would propose to you that the property with the pipeline might lose 50% of the buyers. Half the people aren't even going to come and look at the pipeline, look at the property if they know there's a pipeline running near the home. The other half are going to pay a lot